A very good morning and welcome back. This is Morning Cafe. I am Shiksha Arora and you're watching TV 47. And today on Matters, of course, Law, we discuss matrimonial property division after divorce. And with me in studio, my guest today is Advocate of High Court, Paul Masharia. Thank you so much for being on the show today as we completely dissect this particular topic that is quite a popular one. You know, there's a lot that happens after divorce, and most of the times there's a lot of questions that arise, especially when it comes to property, when it comes to assets. So we'll be talking about that. Remember, you can be a part of this particular conversation. If you have any questions regarding matrimonial property after divorce, do get in touch. The WhatsApp number is 0793-267-279. You can also find us, that is, on our phone lines. Do call us 0795 045 864. Once again, 095 045 864. Call us if you have any questions that you'd like answered about our topic today, which is matrimonial property division after divorce. And of course, Wakili in studio is going to be answering your questions as well with regards to this particular topic. Now, we'll get right into it. Remember, on social media, you can find us at TV47, that is News on X, at TV47 News on X, and at TV47KE on Facebook at Shiksha Arora. That's my handle. All right, good morning to you, Mr. Paul Masharia.
Good morning to you. How are you?
I'm good, thank you.
Yes.
Lovely to see you in studio.
Pleasure. It's my pleasure to have appearance yet again.
Yes.
To tell the viewers and the listeners about this contentious topic. And I would add contagious as well.
Absolutely,
topic
right.
About property and division of the property acquired in the subsistence of the marriage.
Okay, cool. So let's start off with just defining, you know, what matrimonial property is and defining it legally, just to get a better, you know, understanding. If somebody who is not well versed with the term matrimonial property, yes, maybe you can define it better.
Yes, of course, I want to start with the context.
Yes.
And the reason why we call it matrimonial. Of course, it's
Absolutely.
From the matrimony where people are in a marriage setup. And of course, that then takes us to what is a marriage? And of course, we are restricting ourselves to the laws in Kenya. The marriage is an institution, right, and the constitution refers and has a reference to the marriage, which is the context of the family. Okay. Marriage, as per the constitution, is a union of individuals of separate, different gender who are of age. How can they come together? They can either come together through a civil union, that's yes, what we call a civil marriage, or a customary union, that's what we call a customary marriage, okay, or a Christian union, that's what we call a Christian marriage, or through the Hindu marriage or Islamic marriage. Right. So this is the union, or where two people agree of who are of age, agree to be united in a family. That is the context of marriage. Now, when you're talking about the matrimonial property, these are the properties. And we're going to go into them and define them, the specifics of those items. These are the properties that have been acquired during the subsistence of the marriage. Okay. Of course, marriage is an institution which has the start date or the date when the parties agree, right, to be united in the matrimony. Now, after the marriage, any property acquired by the spouses or by either of the spouse, with an understanding that it is for the benefit of the family. Right. It is the matrimonial property. And of course, we are guided by the Matrimonial Properties Act, which is a law that was passed in 2014. Yes. To guide, and of course, in line with the Constitution. Remember, Article 45 of the Constitution, 45.3, gives the parties, Article 45 talks about marriage and a family. But Article 45.3 talks about the equality of the parties in a marriage. Yes. So when you talk about equality, then the issue of the property pops up. When you're talking about that you are equal in the marriage, and actually the Constitution makes it clear that the parties in a marriage, either during the marriage, before the marriage, and after the marriage, yes, they are presumed to be equal in terms of their bargain, in terms of their capacity, in terms of their capability. So when you're talking about matrimonial property, the Act defines matrimonial property into various subsections. And of course, when you're talking about property, property can either be movable or removable. Of course, there are some properties that are fixed, like land, and other properties that are fixed, like house. So, in essence, matrimonial property, as we said, these are the properties acquired during the subsistence of the marriage. They mean and include, one, the matrimonial home or homes. It can be one, or it can be many homes. You know, as long as it's your home, this is where you're using for your residence and for your habitation, it is considered as a matrimonial property. The other subset of the matrimonial property, these are the fixtures, the assets, the fittings in the matrimonial home. So that then matrimonial property is a composite consideration of everything that is there in the matrimonial home. The third subset is where we're talking about the movable and immovable properties acquired during the subsistence of the marriage. That is the definition of the matrimonial property.
Very well explained. Now, remember, there are some key factors that courts have to consider when dividing the properties, and of course the matrimonial properties in particular, because that's what we're talking about. So what are some of these factors that courts have to look into when, you know, a divorce happens and now there is a case of division of property, matrimonial property? What are these factors?
So, the issue of the matrimonial property and division has been in courts profusely after the Constitution 2010. Initially, the presumption of the parties had is that once the property is pronounced a matrimonial property, then automatically ought to be divided in equal shares between the parties. But then there are other considerations, and the court has emphasized that when you're talking about the division of the matrimonial property, and the division as per the law will materially happen after the divorce. And going forward, we will explain why it is after the divorce. Because when the parties come together, they are presumed to have some rights over whatever they are going to get. Now, there is one key consideration that the court considers, and this is contribution. By the time the court is saying, you party A get 20%, you part B get 30% or 60%, there is what the court has considered, or courts are progressively propagating that doctrine of contribution. Now, when you're talking about contribution, the Matrimonial Property Act has also tried to define in simple terms what is contribution. Now, contribution may be in various forms. One, we have the monetary contribution, where you contribute money for the acquisition of that specific property. There are also what we call non-monetary contribution. These are the contributions you do that aid or that help in the acquisition of the property during the subsistence of the marriage. Which are these contributions? One,
monetary, non-monetary.
Yes. Now we are on the non-monetary contributions. We have the child care. You understand, in a union where there are children, you may find that one of the parties is taking more care of children than the other. That is part of their contribution in the acquisition of the property. Two, we have companionship. The law defines as that as part of the contribution. We have farm work. That one of the parties engage in the farm, where the other parties may be doing other things that may help them acquire the property. That is also part of the contribution. And then we have the management of the matrimonial property. It's also considered as part of contribution. So these are some of the non-monetary contribution that the court will look at when it is coming to a decision that this is the property and this is how it's supposed to be divided. But the key consideration is contribution,
Okay.
whether monetary or non-monetary.
Okay. Once again, very well explained. Paul, when it comes to divorce and, you know, the steps that you're supposed to take, obviously there's a lot that happens after you just sign the papers, right?
Yes.
What are some of the steps that one should take to prepare themselves to be able to go to the next step, which is the separation, of course, the division of the matrimonial property after divorce?
Now, the reason why I had previously emphasized on the issue of divorce, because if the setup you have, and I'm calling it setup deliberately, because the setup may, because what we as individuals may refer to a marriage, on the face of law is not a marriage.
Yes.
You understand? There are legally recognized types of marriages in law, and those are the types of the unions that the law will consider.
Okay.
And unless a union or a setup is a marriage as per the law.
And if it's done legally.
Legally.
In fact, just last week we were talking about customary marriages,
Yes.
and why it's very important to legalize those marriages. So I think this is now one of the things where
Yes.
it comes into play, and it's very important. And this is actually the reason why, because previously we had Ruth, who's also an advocate of the High Court, and
Yes.
she mentioned that if your marriage is not legally registered, right, that is your customary marriage, your
Yes.
traditional marriage, what ends up happening is, in the case of divorce, you don't end up getting property, for instance, especially, you know, when it comes to the matrimonial property. So these are things that we discussed.
Unfortunately, that is true.
Yeah.
Because when you're talking about, because the Matrimonial Property Acts clearly defines at what point will the parties acquire ownership
Okay.
over the matrimonial property. It's upon divorce. Now, you cannot purport to be or to divorce as a union that was not legally recognized in law.
Right.
So, if the setup is not per se a recognized setup in law, either a civil union, a Christian union, a customary union,
Yes.
or Islamic union or a Hindu union, then you cannot be able to,
You're not
to
entitled
get, yes,
to any sort of property.
as a result of you being a spouse.
Okay.
You understand?
Yes.
That's why it's very important before you pursue the issue of division of the matrimonial property, you establish, one, you were legally married.
Yes.
And two, you have legally disengaged yourself, or you have legally dissolved or annulled the marriage between yourself and the other party.
Okay.
Because
Yeah.
what happens that once you have separated, no matter the union you had,
Yeah.
then you have the urge to pursue the division of the property. One of the questions that has to be ascertained by the court while determining the issue of the matrimonial property is whether indeed the union between yourself and the other party was a recognized union.
By the law.
By the law. How can we have recognized union? Is through the setups, because the Marriage Act governs the unions. So in essence, every marriage ought to be registered,
Okay.
whether customary, whether civil, whether Christian, whether Islamic, whether Hindu. There is a system on the registration of all the marriages.
Yes.
And unless the procedures required in each specific type of marriage, for example, if you're talking about a customary marriage,
Yeah.
there are some steps that ought to be taken for that specific customs, for them to recognize that indeed this individual is married to this individual.
Yes. Yes.
If those practices and systems have not been done, and the parties are not customarily recognized as such,
You can't contest.
you cannot say that this is
In
my
court.
husband,
Yes.
or
And I
whether
know.
we see you as a husband, that is not a proper test, or your marriage cannot qualify
You need the document.
the test that the law requires.
Yeah. Okay, Paul.
There has been instances, and this is a very intriguing, where the parties go to court purporting to divorce each other.
Okay.
And the court says, I mean, there is no marriage for us to dissolve.
Yeah.
Because in the first instance, there was no a proper setup of a marriage that the law can dissolve. You know, the court acts on what is taken before it.
Yes.
If you do not take proper records of your marriage before the court, what can the court annul?
Okay. Right, now, Paul, when you talk about jointly owned property, you know, when we say that there's some real estate, there's some business interests that we had together as a couple, as husband and wife during our marriage, and now we are going for divorce, and now what happens to this particular property that was jointly owned, matrimonial property, like not just you bought and I bought, we bought together, we have common interests, we have a business together, we own 5 houses together. What happens in such situations?
Now, there is a very unique treatment that the law has given to the types of properties acquired in a matrimonial property, in a matrimonial setup. One, and there are two, we call them presumptions in law.
Okay.
And they are rebuttable presumptions. What I mean is that if there is evidence to the contrary, that initial position can be changed.
Okay.
Okay? That is the meaning of a rebuttable presumption. And there are 2 of them. One, in the acquisition of the matrimonial property, it is presumed that if the property was acquired and registered in the name of one of the spouse, this spouse is holding it in trust for the other spouse who is not registered. You understand?
Yes, 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 yes.
So if we are in a union, okay, and we acquire property and I'm the one who is registered, my spouse has a right to presume I'm holding the property for them in trust. And that can apply to anyone else. That the one that is registered and the property was acquired in the matrimonial union, the presumption of law is that property is held in trust for the other person who is not registered.
Right.
Okay?
Okay.
That is one of the presumptions. The other presumption, when the property is acquired during the process of the marriage or during the subsistence of the marriage, and it is registered in the name, in the 2 names of the spouses, the presumption is that the property equally belong to each other. You get? So it means that if the property is registered during the subsistence of the marriage in the name of the husband and wife jointly, in the instance of divorce, that property is presumed to belong to them equally.
Yes.
Therefore, the share that should apply is equal share.
50-50.
50-50.
Okay.
And I'm saying it is a rebuttable presumption because if there is evidence to the contrary, okay?
Yeah, if one party contests it.
Contest. For example, we can start with the first presumption. If the other party contests that, as much as this property was registered in my name and meant to be held in trust for the other party, it was my property absolutely.
Yes.
Okay? Or I contributed everything.
Yeah. This was not ours, it was mine.
It was my property, not our property.
Yes.
Then that presumption will change in favor of the evidence produced.
Okay. Now, Paul, let's talk about prenups. I feel like this is something that is a new age thing. You know, back in the day, there was nothing like this in the times of our parents, our grandparents, our forefathers. Prenups didn't exist. But now with the modern technology, you know, maybe you can just define what a prenup agreement is between the couple. My understanding is that it's just a sort of paper that you sign with specifics written of who owns what. In the case of divorce, I will still own my money. I don't want to give you any money. You're not entitled to my money that was owned before the marriage. But obviously, you're the person, you know, who's going to give us more details. This is just a common man's understanding of what a prenup is. Yeah, maybe you can take us through what exactly a prenup is. And in the case of a prenup that was signed before marriage, what happens? How does this affect the division of property after divorce? Okay,
the prenup, even from the definition, is a pre.
Yeah, pre, exactly, before.
It's something before. It's before what? Before the parties coming together in a union.
Yes.
So the agreement is, because when you're coming together or when you're getting in marriage, in a marriage setup, one, the individual you are getting married to,
Yes.
they have their own assets and they have their own liabilities. Okay?
Yes.
And they have their own other engagements. And when you're talking about their properties and other items, they even have the properties they have inherited from their parents. Now, the agreement that people agree is that I have come to this union with this. Now, this is mine.
Yes.
This is not ours.
This is not ours.
I met you when you have this amount of loan. That is your loan. It's not
It
my
is not
liability.
mine.
Okay? So it's an agreement based on and for the items that the parties have. And of course, I said the presumption that the property is acquired during the subsistence. Still, the parties can agree that in the event we acquire any property,
Yes.
based on the contribution of either of the party, or if we decide to acquire property, you will contribute this percent, and I'll contribute this percent,
Yes.
and the percentage of your contribution should reflect or should imitate the extent to which you can claim the share of the property acquired.
Okay. Now, Paul, is there any special considerations that are made to property that was acquired before the marriage, especially when it comes to this division of matrimonial property? Are there some cases where, you know, there is some sort of leeway in terms of the court and what the court will rule and how much percent each party will get? Maybe you can just take us through these special considerations. I do know a prenup is obviously one of these special considerations.
Yes.
What else could there possibly be?
Now, for now, I think I can talk about two key points that affect the property that was acquired before the marriage. Okay?
Okay.
Now, one, the property inherited by either of the spouse before the marriage,
Right.
that does not form part of the matrimonial property. That is what the law says.
Okay.
Two, the property acquired before or during the marriage by either of the party, absolutely by themselves or for themselves. The other party has a provision or they can acquire interest in the property acquired by the other party for themselves if they confirm what we call improvement, the contribution on improvement. So when it comes to the division of that specific property, the court will consider your interest, not because of the acquisition, but because of the improvements you have made on that specific property.
Interesting.
And for example, if you buy a house, if either of the spouses buy the house for themselves or any other property, and then the spouse who did not contribute anything or their contribution was not towards the acquisition,
Okay.
improves that property.
Okay, that's a very fair point.
They have acquired interest as a result of improvement.
All right. Now, Wakili, I'll hold you there for a second because we've got a caller actually.
Yes.
So Lawrence has called us from Nairobi. Good morning, Lawrence. How are you today? Florence, I beg your pardon. Florence, how are you today?
Niko salama.
How's everything?
Niko salama. Ningetaka kuuliza,
Yes.
mbona tunaambiwa tufanye equal share of, yani kama mimi nimekuja na mali yangu mimi mwenyewe, niko na shamba zangu, and then sasa tutagawana aje na mimi nilikuja nazo hivyo.
Okay. Wakili,
Yes.
have you heard that question?
So, Florence, sijui nani amewaambia lazima mgawane equal shares. Hakuna mtu anaye uwezo wa kukulazimisha kugawa kwa katikati mali ambao ulikuwa umepata kabla ya ndoa. That is the law. Unless ule mwenzako kuna mambo amefanya kuhakikisha ya kwamba ile mali ambao ulikuwa nao yamepata manufaa. What I'm saying is, to Florence, and I'm trying to answer her in the language she has asked.
Yes, of course.
Maybe that's what she understands. japo ulikuwa na mali, tuseme ulikuwa na shamba. Lile shamba mwenzako akaliekea ua, akapanda mimea pale, akatafuta wafanyakazi. Kwa hivyo kuna yale mambo ambayo amefanya kulifanya likuwe maradufu. Kwa hivyo kila kitu ambacho anaweza kudai ni yale nyongeza ambayo amefanya, lakini si kwa sababu ilikuwa shamba lake.
Okay.
Atafanya madai kwa sababu ya nyongeza aliyoifanya kwa lile shamba.
Okay. All right, Florence, asante sana. Thank you for your call. I hope Paul has answered your question. Remember, you can keep calling us. The number to call us is 0795045864. Should you have any questions about this particular question that we are asking today, where should the division of matrimonial property after divorce be equal, or should it be based on each spouse's financial and non-financial contributions, and why is that? And that's a topic we are tackling today in studio with Paul. Of course, remember you can also find us on WhatsApp 0793-267-279. Keep the messages coming in on Facebook at TV47 Kenya. We've got a message from Adamson Muriuki. Amesema it should be based on wealth or resources or contribution. The same should also apply before your divorce in case you are in debt. People must share what they have. And that's actually very interesting that Adamson has mentioned that, because I wanted to come to that and I wanted to bring that to your attention with regards to debts. Now, what happens if one of the parties was under debt and now they are divorcing, right? So should this also be equal after separation? Does each party also have to pay off the debt, or it should only be, paid off by the person who actually is the one who took it in the first place?
Now, before I respond to that question, the Matrimonial Property Act has defined what we call family business. Family business, it has two definitions. One, this is a business that is run by either of the spouse,
okay,
for the benefit of the family. Okay? The second definition, this is a business where the returns, whether run by either of the party, the return is for the benefit of the family. That is a family business. Okay? Now, the reason why I'm coming to that, because in the event the loan was taken for the family business, then it is only fair that in the event the parties part ways, the liability to be divided in equal shares. Why? Because the benefit was to accrue to the whole family.
Yes.
The same way, the liability is to accrue to the same families. Now, you find that even people in a union, in a marriage, they have their own life. They have their own operations. So, if you take a loan as yourself, as an individual, and you use the loan for your own personal gains and gratification,
yes,
it is unfair that the other spouse partakes in the financing the loan.
Okay.
You get?
Okay.
And therefore, that will take us to some of the special consideration.
This is one of them, debt.
Yes. Special consideration that is to be, or that comes to operations when you are making reference to the matrimonial property.
Right.
And there are a number of them. One, for a matrimonial property, you cannot alienate it without the consent of the other party.
Yeah.
Alienation means you cannot give it as a gift, you cannot lease it, you cannot do anything without the consent of the other party.
So actually, just hold that thought for a bit, Paul, because I also wanted to ask a question regarding the same. These negotiations, can they happen between the parties, between the two parties, or, court has to be the one to decide? So as you said, consent is important. You can't alienate each party, right? You can't alienate your partner, your ex-partner in this case. So what happens? Like, is this a deciding factor as well, where you can have your own negotiations and say, okay, I want 60%, you're going to take 40%, or I want 50-50, or we want 70-30 based on what you've contributed, and then now you go on to court and I guess you present what you've agreed on? Or does court ultimately decide?
Now, the matrimonial property falls under the ambit of the law we call the family law.
All right.
Usually you find that in family law, the courts have given a very wide leeway to the parties to agree. So other aspects of the family law, we talk about succession, we talk about child custody,
yes,
maintenance, division of the matrimonial property, divorce, and such like. Now, you see, the court encourages the parties to agree.
Amongst themselves?
Yes, amongst themselves.
Yes.
It is in the event that the parties cannot totally agree
that's
that
when
the court will intervene.
Intervenes. Okay.
And even in the court intervening, it will consider the contribution, the efforts, the toil, the support by either of the party. Okay? So it is not definite. And the court, you see the reason why the court allows the parties a chance to have discussion, because you see, by the time the parties are making a decision to part ways, they may have gotten children between themselves. They may have done some other more things, okay? And they have also made what we call the emotional contribution. You see, the court cannot be able to really make a decision or determination on the issue of the emotional contribution. So the court allows the parties, because in the event the parties agree that if you divide the property between the spouses, it is possible for the parties to also make an agreement about the children or the child that is as a result of the union.
And when you say emotional contribution, do you mean non-monetary contributions such as childcare?
Yes.
When it comes to emotional support that you offer your partner, taking care of the home, is that what you mean?
Yes, because you see, the court may not be able to really know the amount of, or the magnitude,
the role that you had
of the non-monetary contribution you made. But when we have a discussion, it is easy for the parties to come to an agreement. I concede. Of course, I'll say, I prepared you, I prepared the suits for you, you looked elegant while going to work, I was very compassionate to you,
yeah.
I made food.
I took care of the kids.
Yes, I took them to school.
For 25 years,
yes. So that then the parties can agree. And I've seen it happen where the parties come, they say, I took a loan to finance this project. Yeah?
Yeah.
While you are doing other things for the family, I also did this for the family. This was
my contribution.
Yes,
it
this
may
is
not
my
be
contribution.
Monetary, but it was also very impactful.
Yes. While you are not away, while you are all time away from home, I took care of the construction. I supervised the guys who are constructing the fundis.
Okay.
I made sure that everything is utilized
to
the last coin. You see? Because you see, the court is not aware of what happened between yourself. The court is only aware of what you tell it.
Yeah. Okay.
When the parties agree, it is very easy to come to an amicable position.
Okay.
Because you see, that is why it is easy to concede and to give in, because you consider some of the things that the court may not have an understanding over, Yeah. You may also say, maybe while we are together, I did something for your parents, and which in essence I ought to have done for the benefit of our family, but I did it. So the long and short is that when you're talking about the family issues, the courts give a chance to the parties to discuss.
Okay.
It is unless the parties cannot agree totally that the court will ultimately have to make a decision.
All right. Okay, Paul, we've got another caller. Peter is on the line from Nairobi. Peter, good morning.
Morning to you.
Yes, talk to us. What question or comment do you have regarding our topic today?
It's a question whereby you got married, and in the marriage, the wife came with a son. and you have accepted him to be the son, and then eventually this happens, and you have other children which you brought up together. Now, in the case of separation, and this son starts showing attitude, because he's a grown-up, he realizes that this is not the father, or you have not shown it and you ignore it.
Okay.
And the other siblings also starts to realize, oh, our brother is like, he doesn't want to cooperate. It is like that problem. They realize that also.
Okay.
Now, when in case of a separation,
Right.
and the mother then shares the property the way it should be, the way I've had it, I think is correct. Now, how do you treat the children?
Okay. Interesting question there from Peter. Yes. What would you like to say to that, Paul?
Now, the matrimonial property division does not involve children.
Okay.
It involves the parties that acquire the property. Now, when you're talking about children, there is a separate regime on how to deal with children.
Okay.
We have the children's court. And what happens? The principle is a child should be taken care of by the parents.
Okay.
Whether they are living together or not. Okay? Now, if the wife was married with a child and the husband acquired responsibility over that child, then that husband, whether married or not married to the wife, whether they separate or not, they still have responsibility over that child.
Absolutely. Yeah.
Okay? And the responsibility, at times the law allows to even extend beyond the 18th birthday.
Really?
Yes. There is what we call the extension of parental responsibility.
Okay.
Because this child may have reached the age of 18 while they are still in need of the parental support. They are in school. They cannot support themselves. So as much as you're saying they are adults, they still need the parental support.
Okay.
And the parental support should be both parents have equal parental responsibility. Equal does not mean, does not necessarily mean 50-50.
Yes.
Because either of the parent may have different potential. What it says that you should equally support that child.
Okay.
If one parent is paying for the fees, you pay for the other needs. Households, clothing, shelter, medical care, support.
So there should be a contribution from both parties?
Yes.
Yes.
Equal contribution,
okay,
or equitable contribution, depending on the strength of the parties.
Okay.
Therefore, when you're talking about, and you see, why I said at times it's even very, very healthy to have such a discussion, because you can say, instead of us dividing this property 50-50,
yeah,
let us share 30-30. The other portion goes to the children.
Okay. That's also a smart way to do it.
You understand?
Yes.
So that whatever I get is absolutely mine, or whatever you get is absolutely yours. And at times you see, the parties may agree. We either dispose of that property, or we share the proceeds of the matrimonial property.
When you say dispose, you mean sell it? And
You sell it, you divide the money.
the profit, yeah.
Yes. Or you continue operating it, or the other party can buy the other out, or you agree on how the division of the proceeds.
Okay, okay.
You see, you can say, instead of us dividing 50-50 the proceeds that comes from the property,
yeah,
you take your 30%, I take my 30%, the other portion goes to the support of the children.
Okay, interesting. Thank you very much for that. I hope that answers your question, Peter. Now, we've got a message on Facebook. Remember, you can find us at TV47 Kenya on Facebook. Keep the comments coming in, keep the interaction. We've gotten one that says, remember the time the wife is getting and taking care of children back at home and a man is at work. To me, the division of properties should depend on who is remaining with the children or a child. So you see, this is also a very controversial, point, because everybody seems to be having a different opinion on this, and we've already discussed this, right?
Yes.
And you did mention that, yes, there is some non-monetary contribution. So in such a scenario, if, for example, the wife does not own anything, she's not contributed to anything in a monetary way, what happens in such a case? Does she still get some percent of the matrimonial property?
One, I wish to correct with humility that the wife does not own anything.
Yeah.
Anything acquired while they were married, they own it.
Together?
Yes.
Okay.
What varies is what is their contribution.
Yes.
You see, you cannot say, as
Financial
a husband,
contribution.
I have owned everything since we got married. That is not correct.
Okay.
Because you may have contributed financially towards the acquisition of that property, but your spouse also contributed non-monetary.
Yeah.
That while you're at work getting the money, the wife was taking care of the domestic work, was managing the family property, was taking care of the children, was very compassionate or companion towards you, was also managing the family business. You see? Okay. Was also part going to farm, doing all the manner of things, so that you cannot, in all fairness, say that this is my property.
Yeah.
Because I paid cash.
No.
Also, the wife contributed or assisted you in the acquisition of that property.
In one way or the other.
Yes.
Right.
So let the other spouse not see that they have not done anything. And you see, it's not a competition.
Yes.
That now that I am staying in home or at home, you should also stay at home and I go to work. I mean, the parties should support each other. And the contribution should be, at least you contribute, because you're also contributing
in one way or the
monetarily.
other.
Yes.
Right. Thank you very much for that, Paul. So lots of messages coming in. So these are actually interesting. Engineer Mash amesema hapo kwa contribution, that should be key. So again,
you see, the courts have been very alive to that fact.
People have that misconception that if I did not contribute to this particular property financially, I'm going to be saying that in bold, in caps, financially, then my partner does not have any right to ask for it if they did not contribute. It is mine and mine alone because I paid for it with money.
No, that is a very wrong presupposition and presumption, because that is not true. That is not correct.
Another one.
And I'm not the one who is saying that. It is the law.
Yeah. Actually, another message from Dantes, who's also said the same thing. It should be based on financial contribution. Interesting.
Not really, because you see, contribution has been defined by the Act.
Yeah.
There is difference between what I want and what there is in law. Okay. Of course, and I've seen these, for the husband who acquired it and probably registered, or for the wives who acquired it and they are registered, for them they want it to be that because I paid money, it should be mine.
Yeah.
For the wife, or for the other party who took care of the children, they are saying, because I took care of the children, it should be mine and not theirs. But you see, both of you contributed.
Yes.
There is the monetary contribution and there is the non-monetary contribution. And I also wish to dissuade the viewers.
Yeah.
At times we presume that it is the husband who has the higher or who has the leverage to acquire. You know, the dynamics have changed.
Financial capability.
You even find the wife is more capable financially than the
yes.
Yes.
Times are different now.
Yes.
Have definitely
No,
changed.
if the husband acquires and says it is mine, why then would they feel aggrieved that if they also contributed in some way or the other, and then the wife says it's theirs?
Yeah.
So the law tries to balance the interests of the parties.
Okay.
On the presumption that both parties have the capacity and have the potential to equally contribute.
Okay. Right now, Paul, let's talk about ways when you can protect yourself, right, before marriage. Of course, a prenup is one of them, and also during the divorce. How do you protect yourself and your property? Maybe you can just advise people who are watching, if you want to get married to somebody and you're thinking, this is it, this is the end goal, and then now they're having second thoughts during that marriage. What should they do before it leads up to divorce?
Now, my advice would be let both parties contribute.
Okay.
be it financially, be it otherwise. Make sure you contribute. That is one. Two, if possible, let both parties be registered. Okay? If possible. If this property was registered in your name, then you can agree between yourself that now that you have property that is in your name, in the other property we get, may I also be registered?
Okay.
Right?
So make sure you have documents to show, for example, a car, for instance, title deeds.
Yes.
What happens to that? Actually, that's also interesting because I just remembered there's things like cars, we have gifts, we have inheritances.
Now there is
like this,
there is what
happens?
the law says, which is very interesting. The gift. Once the gift is given, the law presumes that the gift is given to the receiver. Absolutely.
Okay.
If I give you a gift in the substance of marriage, I cannot come to reclaim it.
Interesting.
That is the law. That's
the law actually states that.
Yes.
Wow.
The gift given in the substance of the marriage is given absolutely.
So your partner during divorce can't come to you and be like, where's the ring?
It was a gift.
Where's the car?
It was a gift.
Okay.
Now, we were talking about how the parties can safeguard themselves.
Yes.
Now, the third way, make sure that you formalize your union. Okay?
Of course, and that's the biggest mistake that people do. They don't formalize their union, register it legally.
Yes, formalize your union.
Yeah.
So that now there are avenues. You can register your marriage through there are forums where you can have your marriage registered and you're issued with a marriage certificate. The fourth way, make sure you are involved consciously and by way of writing to give consent for anything that is happening for the matrimonial property. Because one of the special conditions that the law gives is that one, and I can state them quickly, the matrimonial property, as we have said, cannot be alienated without the consent of the other party.
Okay.
Two, the matrimonial property cannot be mortgaged, cannot be charged without the written consent of the other party. Three, neither of the spouse can be evicted from the matrimonial home unless, one, by way of a fulfillment of a court decree, two, because of the bankruptcy, or three, because of the chargee, which normally the bank exercising the power of sale. And even then, the court allows the eviction of either of the spouse from the matrimonial home by way of a court order. You cannot just evict a spouse from the matrimonial home. So in any dealing between the for the matrimonial property, make sure that you are involved. Failure to which the law gives you a right to place a caution, place a caveat, and all the other necessary instruments that can prevent the other party from dealing otherwise with that property.
Okay. Okay. Interesting.
But then, for you to be able to succeed in that, one of the key considerations, are you married to this guy? If you're married to this guy and the property is theirs, you're allowed by law to either place caution, place caveat, place prohibition, in any way to prevent the guy from maliciously dealing with the property in a manner that prejudices your interest.
Okay. Now, Paul, as we wrap up, there's one thing that a lot of lawyers will know. Of course, if you've read about law and you've read about the Marriage Act, you know what happened back in 2007 with the Sharia versus Sharia case. That was the landmark case on matrimonial property, and what happened after the court ruled that 50-50 was going to be how the property would be divided. But then there was a Court of Appeal ruling, and after this, the Court of Appeal ruling actually overturned the High Court's decision, and it ruled that the matrimonial property should be divided based on the direct contribution of each spouse, right? Of course, things have changed since then, because that's after which the Marriage Act came about. That is in 2014, if I'm not wrong, right? So have you in your career experienced, cases that are anomalies where the court has ruled something that nobody expected? For example, the court has said that the wife will not be getting anything, and they will not consider any sort of non-monetary contribution. Has that happened before?
Yes, it has happened, and one of the instances where the court declined to grant divorce.
Oh, okay. Now that's a special case.
Yes. You're going to court saying, I want to be divorced because of we did a customary marriage, we did this, but there is no evidence. The court dismisses the case.
So they can't even give you that decision that you can be legally divorced because you are not legally married in the first place.
There is nothing to unearth. There is nothing to break.
Interesting.
Now, another instance where the court dismisses the claim for division of the property because there was no marriage.
Okay.
Proved marriage, and there was no divorce that is proved.
So what property are you dividing?
What property are you dividing? It's only
not matrimonial
and you see,
property.
The importance of that is that you safeguard the property because there are so many individuals who may want to get interest for the properties that do not essentially belong to them, or they are not in formal unions as a result of marriage. And I think before we conclude, there is one very important thing I wish to mention.
Yes.
In a polygamous union.
Exactly. What happens in such a situation?
Now, what happens?
A man or a woman is married to multiple people.
Now, in the first instance, the property acquired between the husband and the first wife is presumed to be shared equally.
Okay.
Okay? Are we together here?
Understood.
Then the other, if the husband acquires property while he has other wives, that property is presumed to have been acquired by all the parties, subject to their contribution.
Okay.
So where there is a polygamous union and the property is acquired, all the parties in that union have an interest, subject to proof of their contribution. And we said contribution can either be monetary or non-monetary.
Okay.
So even in a polygamous union, where you are able to show or to demonstrate that you made a contribution, you have a share in the property.
Okay.
Now, if, for example, the husband divorced the first wife, as a time of the divorcing, the property acquired between him and the wife, that is the property to be divided between themselves equally.
Okay.
Okay. Now, if he continues to acquire property and marry other individuals, as from the time of the marriage, the property, then they will get their share on the contribution and also on improvement.
Okay. It's quite complicated though, isn't it? Sometimes.
A bit complicated.
Yeah.
And what it make it complicated, think of a scenario where one is in a customary union.
Okay.
Okay. You have the first wife. You get a magnitude or number of properties with them. You marry the second wife. You get the properties. You know, this second wife may be malicious to even get more interest on the properties that was acquired while she had not been married.
Yeah, true.
You see?
True.
And that's why the law is insisting, what is your contribution?
Okay, interesting. I feel like we can continue this conversation for the next
cannot end
5
because
hours. But you know, as for the interest of time, we have to wrap up.
Yes.
Maybe as we wrap up, Paul, you could give us your closing remarks and some advice on how to deal with such situations, especially to married couples. What advice would you like to give them? I know you've been emphasizing on registering your marriage. What else would you like to tell married couples who are going through divorce or are about to initiate that divorce? What would you like to tell such people?
What I would like to tell the viewers is that some things are inevitable.
Yes.
Of course, yeah. And you cannot continue staying in a very toxic union because you are following the property. It is possible to have yourself and the other party severed in a manner that does not cause bodily harm to you and to other parties. Because you see, some people even go to the extent of planning or scheming for things for the other party. You want them arrested, You have them charged because you want to disentitle them
To
their
property
share.
or share.
So there are avenues available in court, in and out of court,
Okay.
to ventilate and to help you secure your interest. So don't kill yourself, don't kill any other person, don't kill the other, don't die.
There's avenues
There is
which you can get your
there is
right.
even life after divorce.
Absolutely.
Okay. There are some people even say that I even don't want that property.
Yeah, I just want
Just
peace
keep
of mind.
it.
I
Okay?
just want to be happy.
Yes, keep it.
Yeah.
So there is life of this. Some things are inevitable, and of importance is make sure you are sane and you are moving on with life.
Okay, thank you very much. Of course, I have been speaking to Paul Macharia, advocate of the High Court. You know, quite some valuable insights there when it comes to matrimonial property and how to deal with divorce. What happens to the matrimonial property, you know, when it comes to the division of this particular property that you had as a couple. So we'll be discussing more of this every week. We do this on Thursday from 8 to 9 a.m. right here on TV47. This is the Morning Cafe Show. I am Shiksha Arora. Thank you so much for being a part of this conversation online as well as while calling in. We appreciate it. Now remember, Fitness Thursday continues right after this short commercial break. I have Akach Vincent, who is a professional boxer, award-winning boxer.